Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In our video titled Rebuild or Reform, Mr. Henley KC's findings on the Criminal Cases Review Commission, we took a close look at Mr. Henley KC's report on the CCRC's handling of Mr. Malkinson's case. In our conclusion, we posed a critical question. Is Mr. Malkinson's case an isolated incident, or does it reflect a broader pattern in the CCRC's conduct? Based on Mr. Henley's remarks to The Guardian, that it would be worryingly complacent simply to pass this off as an isolated case, we concluded that if Mr. Henley KC's criticisms were to apply to even a few more cases, it is clear that nothing short of a comprehensive overhaul of the CCRC is necessary. This week's video is the first in a two-part series where we will explore two cases which were submitted to the CCRC. Our goal is to determine whether the issues highlighted by Mr. Henley KC are also evident in these cases. So today we ask, could the cases of Jeremy Bamber and Jason Moore be among those where the CCRC's superficial and insufficiently curious approach found by Mr. Henley KC in Mr. Malkinson's case is at play once again? In this week's video, we will examine the case of Jeremy Bamber, best known as the White House Farm murder. We'll then explore the case of Jason Moore in our next week's video. Starting with the Jeremy Bamber case. In the early hours of the 7th of August 1985, Neville and June Bamber, husband and wife, were shot and killed inside their farmhouse at the White House Farm near the village of Tolshen Darcy in Essex, along with their adopted daughter Sheila Caffell and her 6-year-old twin sons, Daniel and Nicholas Caffell. The only surviving member of the family, Jeremy Neville Bamber, who, like Sheila, had been adopted by the Bambers and lived nearby, reported at around 3 a.m. to the local police station that he had received a call from his father, who had alerted him that Sheila, his sister, who had a history of mental illness and had been diagnosed as a paranoid schizophrenic, had gone crazy. She's got a gun. When the police arrived at the farm at around 4 a.m., they were joined by Mr. Bamber. Believing they were dealing with the hostage situation, the police waited outside the farmhouse until approximately 7:30 a.m. before entering and discovering that all the occupants had been shot dead. The initial police investigation concluded that Sheila had fired the shots, killing everyone before turning the rifle on herself. However, as the investigation progressed, they concluded that Jeremy Bamber was the perpetrator. Jeremy Bamber, however, has always maintained his innocence. Our usual word of caution here: by discussing these tragic events, we do not mean to cause any distress to anyone who has been affected. We particularly refer to Mr. Caffell, the ex-husband of Sheila Caffell and the father of Daniel and Nicholas. For balance, we report that he has expressed strong views about Jeremy Bamber over the years. Initially, like many others, he was shocked by the murders and believed that Sheila might have been responsible given her history of mental illness. However, as the investigation progressed and given the evidence presented at trial, Mr. Caffell came to accept Bamber's guilt. In interviews and in his book In Search of the Rainbow's End, Caffell has described the profound impact on him and how he had to come to terms with the fact that Bamber a family member was responsible for the brutal killings. Mr. Caffell has spoken about how difficult it was to reconcile the person he knew with the person capable of committing such an atrocity. Over time, Mr. Caffell has expressed that he believes that Mr. Bamber is guilty and that justice was served with his conviction. We respect his view, but we recognize that it does not have direct knowledge of the tragic events of that night, and at Spoken Injustice we take claims of innocence seriously and approach cases from the perspective of those who assert their innocence, while of course maintaining full respect for the original victims. So returning to the case with this premise in mind, the investigation took a dramatic turn when the police could not verify the call Mr. Bamber claimed his father made to him. The absence of blood stains on the phone receiver and the fact that it was more likely that the father would have called the police rather than his son led to the conclusion that the only way Mr. Bamber could have known about the events was if he had carried out the killings himself. The prosecution case relied heavily on this detail, along with testimony from Mr. Bamber's ex-girlfriend. Although she initially gave a different statement, after their breakup, she informed the police that Bamber had in fact confided in her and that he had been planning to kill his family for some time. Additional facts of the prosecution case included that while Sheila had a history of mental illness, there was no sign of any deterioration in her condition leading up to the tragic events. Furthermore, she was not known to have used guns, and it was unlikely she would have been strong enough to overpower the father in a struggle. And indeed, there was evidence that there had been a struggle. Her hands and feet were found clean, and gunpowder residue was not detected on her hands. Moreover, it was determined that she could not have used the silencer to kill herself, as she wouldn't have been able to reach the trigger. However, blood found in the silencer, which was consistent with hers, indicated that it was still attached when she was shot. The prosecution also presented a motive, arguing that Bamber stood to gain a significant inheritance from the killings. The prosecution also relied on testimony from several family members who were called as witnesses and all attested to Jeremy Bamber's odd character. Notably, each of these individuals stood to benefit from Jeremy Bamber's conviction. On those bases, on the 28th of October 1986, Mr. Bamber was convicted of 5 counts of murder by a majority of 10-2 following a 19-day trial in the Crown Court at Chelmsford before Judge Drake and a jury. He was sentenced to life imprisonment. Following his trial, he sought leave to appeal against conviction. His application was initially refused on the papers by a single judge. However, this was renewed to the full court. On the 20th of March 1989, the full court dismissed his application. In 2002, the case was referred back to the Court of Appeal by the CCRC on one ground based on fresh DNA evidence. However, 15 additional grounds of appeal were submitted by the defense. The additional 15 grounds were mostly related to allegations of police non-disclosure and/or misconduct. The Court of Appeal dismissed all the grounds non-related to the CCRC referral. As per the new DNA analysis, the only ground upon which the CCRC referred the case, these had revealed DNA presence in the silencer which belonged to Mrs. Bamber, but none that belonged to Sheila herself. The defense submitted that the absence of Sheila Caffell's DNA was significant and that the fresher evidence severely undermined the Crown's case against Mr. Bamber as it was presented to the jury. However, the Court of Appeal decided that this fresh DNA evidence did not undermine the original blood evidence revealed at trial, which had found a flake of blood which was said to be consistent with Sheila's. The Court of Appeal stated, "We are satisfied that the DNA evidence does not lead to any conclusion that the verdicts were unsafe. They do not in any way establish how June Bamber's DNA came to be found in the moderator many years after the trial. Even if one were to reject the possibility of contamination and conclude that June Bamber's blood got into the moderator during the shooting, that would not mean that Sheila Caffell's blood was not in the silencer. The flake of blood that was group tested was independent of the DNA found on the baffles, which was attributed to June Bamber. The evidence about the blood testing is not, in our judgment, in any way diminished by the DNA findings, even if one ignored the whole issue of contamination at a later date. In our judgment, having reviewed the whole of the evidence about the blood, there is nothing to suggest that the evidence of Mr. Hayward, the prosecution expert, in this regard is wrong. The evidence did point to the blood being that of Sheila Caffell, but he was right to acknowledge the remote possibility that there was a mixture of blood from June Bamber and Neville Bamber. That possibility could only be overcome by considering the other aspects of the evidence: the lack of any blood in the barrel of the rifle, the finding of the moderator carefully put away in its proper place, and all other unrelated aspects of the case. We can find nothing to suggest that the evidence that was placed before the jury was misleading, nor that the jury would not have given due consideration to this aspect of the case. Accordingly, we reject this ground. The final ground of appeal is a generalized allegation that as a result of the activities of Detective Superintendent Ainsley, D.S. Jones and DCI Wright, as detailed in grounds 1 to 13, the prosecution case is tainted and the convictions therefore unsafe. The court say we can see no reason to revise our view on any of the matters, and we have found no evidence at all to support the allegations of serious wrongdoing by the police that is suggested. Having considered and rejected each of the grounds advanced on behalf of the appellant, it follows that this appeal must be dismissed. Each member of the court has reached the conclusion that there is nothing in any of the matters raised before us that throws doubt upon the safety of these convictions. Before we embark into the rest of this case history, if you are finding this video helpful, please give it a like, and if you haven't yet, subscribe to our channel to join the Spoken Injustice community. Returning to the Jeremy Bamber's case, it is understood that in 2011, a partial disclosure of several police logs, which had not previously been provided to the defense, led to a further submission of the case to the CCRC. However, the CCRC rejected the submissions. In 2020, following complaints by Mr. Bamber made against Essex police, which were subsequently escalated to the Independent Office for Police Conduct, the IOPC, resulted in the IOPC findings that Essex police had not dealt with the complaints in a reasonable or proportionate manner, and that they had breached their statutory obligation to refer serious complaints directly to the IOPC. This was after being recorded by the force that received them, because Jeremy's complaints met the threshold in the IOPC Statutory Guidance 2020. Owing to the death of the two officers at the centre of the complaints, DCI Ainsley and DI Ronald Cook, who were alive at the time when the original complaints were filed, the IOPC stated that they could not take further action and that the CCRC was the correct body to investigate the substance of the complaints. Consequently, a third submission was made to the CCRC in March 2021. 5 months ago, Philip Walker, a director of the Jeremy Bamber Innocence Campaign, the JBIC, speaking as a guest on Talk TV, revealed at least 3 facts indicating that Mr. Bamber is innocent. First, there is evidence that Sheila was still alive after the police arrived at the farm at around 4 a.m. while Mr. Bamber was with the police. According to reports, while surveying the house, Bamber and the police observed movements in an upstairs window which prompted them to call for firearm support. Additionally, lights were seen turning on and off at various times and curtains were being opened and closed. Secondly, police records indicate that they were in conversation with someone inside the house. A 999 call was received from within the farm while the police were outside. Third, when the police finally entered the farm, it was noted that there were 2 bodies in the kitchen, a male and a female. However, subsequently, only the father was found dead in the kitchen. It is believed that the female was Sheila, who must have been unconscious, and after the police breached the property, she must have woken up, ran upstairs and committed suicide. He also mentioned that the police logs have revealed that there were actually 2 calls made to the police that night. One from Jeremy Bamber and another from his father. This second call was made while Jeremy Bamber was at his cottage, meaning he could not have been at the farm at the time. We understand that the CCRC is still investigating these submissions. The time the CCRC is taking to investigate this further application led to a demonstration held on the 10th of May 2024 outside the CCRC headquarters in Birmingham. Indeed, we reported it in our video, Criminal Cases Review Commission, Last Gasp or Survival. On the 29th of July 2024, an article by Heidi Blake in The New Yorker revisited the White Farmhouse murders, highlighting the newly uncovered evidence. The article, titled "Did the UK's Most Infamous Family Massacre End in a Wrongful Conviction?" explores the implications of this new material. So in light of all of this, let's revisit our initial question. Could Mr. Bamber's case be yet another instance where the CCRC has fallen short of being the robust, well-resourced and mission-driven organization it needs to be? An organization that, as Mr. Henley KC has emphasized in his report, should fearlessly ask the right questions, rigorously analyze new evidence and submissions, and most importantly, accurately identify the cases that deserve to be referred for further review? Does the handling of Mr. Bamber's case exemplify the shortcomings that Mr. Henley KC warned about? Let me know in the comments below. I hope you have found this video interesting, and if so, like it and subscribe to our channel. Also join our networking hub at spokeninjustice.net to have your say as to the content of this channel. Join us again as we sit and rise in this unique trial.